Good afternoon and good morning in the Midwest and in the West Coast. Welcome to the webinar on democracy, voting suppression, and voting as a human right. My name is Tom McDonald. I chair the International Human Rights Law section and teach international law and international human rights law at Pace Law School. We have kind of an unusual situation. One of our speakers is on a plane, actually. His original flight was diverted, and now he's going to be speaking us from the airplane. Okay. So let me introduce Juan F. Perea. He is the Kurt and Linda Roden Professor of Law and Social Justice at Loyola University, Chicago Law School. He has also served as a visiting professor at Harvard Law School, University of Virginia Law School, and University of Michigan Law School. Professor Perea has written extensively on racial inequality and the legal history of race and racism in the United States. He is the lead author of Race and Races, Cases and Resources for a Diverse America, West, 4th edition, 2022. Okay. It is a leading textbook on race and law and is used throughout the country. He will be discussing Echoes of Slavery, how slavery's legacy distorts democracy. Juan? Start whenever you're ready, Juan. You're muted at the moment.
You're muted.
Yeah, okay. Now I'm unmuted. Sound okay now?
You sound great.
Okay, thank you, Tom, and thanks to my colleagues on the panel. I'm very happy to be with you today. I want to begin by talking about the results of the Electoral College. So over the last, up until 2020, 40% of the winners were people who lost the popular vote. So in the year 2000, Al Gore won the popular vote, but he lost the presidency. And in 2016, same with Hillary Clinton. It's remarkably consequential at the Electoral College because we end up getting presidents that most people didn't vote for. So in Bush's case, we end up with Supreme Court appointments of Chief Justice Roberts and Justice Alito. We end up with wars in Afghanistan and Iraq. And I'm abbreviating. I mean, I'm just pointing out some lowlights. Under Trump's presidency, we had incompetence during the pandemic, over 1 million lives lost, 3 Supreme Court appointments, Justices Gorsuch, Kavanaugh, and Barrett. Those 5 justices that I mentioned are 5 of the 6 justices that overturned Roe, have been gutting the Voting Rights Act, are likely to overturn affirmative action. And of course, Trump is responsible for a lot of instability in our democracy. And, you know, I don't know how things would have turned out had the winner of the popular vote become president in those years, but I'm pretty sure it would have come out better. So the Electoral College has huge consequences. I'm going to talk a little bit about its history and then also about state voter suppression. First, it's important to understand that the Constitution was a pro-slavery document, by which I mean it encouraged slavery and it protected slavery. The protection of slavery goes to the heart of the Constitution. You see it in the Apportionment Clause, where 3/5 of enslaved people are counted for purposes of representation in the southern states. You see it in the slave import limitation, which provides for unregulated slave importation until 1808. You see it in the Fugitive Slave Clause, which creates the national right of recaption that didn't exist before it. And remarkably, Article 5, which is the part of the Constitution that allows for amendments, provides that the slave import limitation cannot be subject to amendment. It's one of only 2 provisions that are like that. But there are other slavery protective provisions, but those are some of the main ones. With regard to the Electoral College, I mentioned the Apportionment Clause, and that formula, adding 3/5 of the number of enslaved persons to the number of free persons, was incorporated into the presidential representation through the Electoral College. So it incorporates the apportionment clause by reference to create a number of electors and giving extra political power to the southern states. Madison recognized that a more direct kind of democracy, or a more direct kind of representation, might have been preferable, but he recognized that that wouldn't be possible because the southern states would never agree to a situation in which they were always outvoted. Because the number of free people in the South is much smaller than in the North, without something like the Electoral College, the South would have been outvoted every time. So that's the reason we had the Electoral College, is to boost the political power of southern states with regard to presidential elections. That seems to be the reason, and other arguments have been developed after the fact, but it was there as a matter of slavery protection, and it's pretty remarkable the kind of consequences that we all have to live with as a result of something that was intended to protect slavery. In terms of what we might do about it, there'll never be an amendment, I think, because each party that wins a presidential election is not going to want to, will have benefited from the college and is not going to want to change that. So there is a national popular vote interstate compact, which provides that when the number of compacting states reaches 270 electoral votes, then those 270 votes will be awarded to the winner of the popular vote. So that's a way of making sure that the winner of the popular vote also wins the presidency. And as of 2022, there are 16 jurisdictions with 195 electoral votes. So we need 75 more for that to take effect. Okay, another huge issue is the fact that states get to set voter qualifications and often use that to suppress the votes of especially minorities. But so probably are aware the Constitution doesn't guarantee any right to vote. The rights to vote are guaranteed by the states, but that means the states can set conditions and qualifications for using the right to vote. There are several amendments on point, in particular the 15th Amendment, which prohibits race discrimination in voting. But there was a very huge and violent reaction after the 15th Amendment, suppressing Black voters and reinforced by ostensibly neutral law like grandfather clauses and poll taxes and felon disenfranchisement and literacy tests and white primaries. And for the most part, Black voters were not reasonably able to vote until the Voting Rights Act of 1965. So it's a fairly recent phenomenon that Black voters are able to represent themselves effectively. The Supreme Court has enabled a huge amount of voter suppression. In Crawford versus Marion County in 2008, they approved voter IDs. In Shelby County versus Holder, they eviscerated the Voting Rights Act. And in Brnovich versus DNC, they eroded Section 2 of the Voting Rights Act, which is basically what's left after Shelby County. So since the beginning of 2021, lawmakers have passed at least 42 restrictive voting laws in 21 states. These laws make it harder to vote in several ways. They make it harder to vote by mail. You have to give documentary proof of your citizenship for voter registration. They impose new photo ID requirements, limit election day registration, make it more difficult for individuals without traditional addresses to register. and they increase the likelihood of faulty voter purges. So all of those things are restrictive laws that have enacted since 2021, and some of which will be in effect in the midterm elections coming up. There are also election interference laws that create the possibility of partisan interference or risk to people and election workers. So at least 6 states have created new criminal or civil penalties for election officials. At least 2 laws in 2 states dedicate new resources toward pursuing election crimes against voters or election officials. Think there perhaps about Ron DeSantis's new election police force in Florida. And the laws intimidate election officials, election workers, and voters. In addition, there's been a lot of legislation rearranging who can regulate elections, who can declare the results, and more power has been transferred to partisan actors, and there are less checks and balances. In Georgia, for example, Georgia shifted authority over elections from experienced election administrators to partisan-controlled county election boards. In addition, in Georgia, forbids any state entity, including the governor or a state election board or state courts, from altering or amending election laws. So there's no more check and balance on what the legislature does. Those statistics and laws come from a recent report by the Brennan Center, and I just want to give credit for that. So let's go back to 2016 when Donald Trump won. In Wisconsin, approximately 200,000 voters were suppressed. That's one estimate. And Trump's margin of victory in Wisconsin was 22,748. So roughly 10 times as many voters were suppressed as Trump's margin of victory. So it's reasonable to think that he might not have won Wisconsin had those voters not been suppressed. The remedy for state-centered voting discrimination is to make voting as easy as possible. And with a different Supreme Court, strict scrutiny of any additional burdens on voting in the manner that the Voting Rights Act used to do. So basically, voting should be as easy as possible, and there has to be regulation, which the Supreme Court has been dismantling. I want to talk a little bit also about felon disenfranchisement. So this is a post-Reconstruction technique to disenfranchise Black voters, like some of the other conditions I mentioned. The idea was to criminalize things that were thought to be associated with Black life. So white legislators wanted to make crimes out of what they thought Blacks did. So vagrancy became a crime, insulting gestures or language was a crime, preaching the Bible without a license, also a felony. In addition, former misdemeanors were reclassified as felonies. So things like petty theft, crimes of moral turpitude like vagrancy, adultery, wife beating became felonies. Where they had been misdemeanors before, rightly or wrongly, some of those. So it's interesting to look at what is considered to be a felony today, because there's a kind of surface appeal of felon disenfranchisement, especially with respect to serious crimes. However, violent crimes like murder, those sorts of crimes, they're only 19% of the number of felonies. So 80% of felonies are not violent. And among the list of contemporary felonies are possession of 1 ounce of marijuana, public indecency, other drug offenses, passing bad checks, using fake IDs, possessing fireworks without a license, and in Texas, stealing any wool, mohair, or edible meat. That's a felony. So if you're convicted of any of those things, you will lose your right to vote in the respective states. This was the strategy of Southern whites to disenfranchise Blacks by convicting them of felonies, putting them in prison, then leasing them out to plantation owners. And creating a cheap labor force at the same time as disenfranchising potential voters. So with respect to felon disenfranchisement, in 2016, 6 million persons were disenfranchised because of felonies, which seems to be the high point. It's diminished a little bit to 5.2 million persons in 2020. And of the 5.2 million, 3.9 million are not incarcerated. So these are people who have served their prison sentences and are out of jail. Black adults are disenfranchised 3.7 times more than non-Black adults. And only 2 states don't disenfranchise felons, Vermont and New Hampshire. And it's probably not a coincidence that those 2 states are over 96% white. So what is easy to do when felons are people of other colors, apparently is harder to do when it comes to imprisoning white people who look like the legislators.
I know. I'm gonna go make it happen. I know.
Now, felon disenfranchisement was probably outcome determinative in 2016. I said 6 million persons disenfranchised because of felonies. Yes, one estimate is that 70% of disenfranchised felons would vote Democratic. So that's quite a large number.
Or maybe they can't.
Hello?
Yes.
Yes, hi. Something changed, I'm not sure what. Can you hear me still?
Yes, we can hear you.
Okay, well, let me finish then with these stats, which are pretty revealing, I think. So in Michigan, so I'm going to go over some of the swing states. In Michigan, there were 44,221 disenfranchised felons. And Trump's margin of victory in Michigan was 10,704. So 4 times as many disenfranchised felons as Trump's margin of victory. In Wisconsin, Trump's margin of victory was 22,748. The disenfranchised felons were about 66,000. So roughly 3 times as many disenfranchised felons as Trump's margin of victory. In Pennsylvania, the margin is smaller, but still more. Trump's margin of victory, 44,292, and disenfranchised felons were 52,974. So in those states, it's very likely that Trump would have lost had felons been able to vote. And so then it becomes very important as a remedy to enfranchise felons, which seems to have begun, and that accounts for the smaller number of disenfranchised felons now as opposed to 2016. But more needs to be done there. So a good progressive agenda would be to cultivate support for the National Popular Vote Interstate Compact, make voting as easy as possible, and then enfranchise felons. Okay, so that's what I have for you. And I look forward to my conversation for as long as I can stay with it.
Thank you, Juan. The way we're going to work it today is that my colleague, Lisa Griffin, is going to be asking each of the speakers a question, and then at the end, we'll open it up to the entire audience. So Lisa?
Well, thanks, Tom. Professor Perea, I read your article. I think you did a beautiful job, although a depressing job, of laying out the history of race and being entrenched in our politics and our voting. And so I wanted to ask you, given your expertise, what do you think we should do next? What is the most realistic thing we could do? And you mentioned, franchising felons. You mentioned getting states to join the interstate. I would be curious to know how the interstate compact, how the state does join, whether it's state legislature or governor, what is the process for that? But also, when I was reading Professor Klarman's works, I was thinking about this interesting suggestion that we create more states. That we make Puerto Rico and DC states, which which I would have said years ago seems equally impossible, but since so much of it seems to depend on the vote, everything seems impossible. So I was just curious, what do you think is the best thing we could do to change course here?
With respect to voting or more generally?
With respect to, I mean, getting race out of I don't know, with respect to changing the course, the degradation of our democracy, the minority election of a president, the subsequent minority representation on the court, all of these things, it feels like I'm chasing my tail, because it all comes down to voting. And I don't really, I would just like to hear your thoughts about all the things you proposed. Seem very difficult to me. So like, what would you suggest maybe is the most realistic?
Ironically, those are the easy ones. Those are the easy ones because they're at least possible in a foreseeable universe. They're possible. But I think Democrats have been terrible at emphasizing the importance of the vote. There's been no visibility, little to no leadership, and it's really, to me, it's unforgivable, but I assume somebody knows what they're doing. You can't purge race from the Constitution because it's there. It's a structural part of the society and a structural part of our fundamental law. And I think empowering formerly disenfranchised people is really, really important. But race, I can't imagine it'll never be irrelevant, and so, which is why there has to be effective regulation. And of course, the Supreme Court's dismantling that. So, yeah, it's not a great time, but one can. Why aren't Democrats teaching people about the interstate compact?
Mm-hmm.
Why aren't they rallying for enfranchising felons, which actually did happen in Florida, and then it was taken away.
And then it was reversed, right?
Yeah, right. So one would think, it's not true, but one would think that there could be bipartisan support for reducing the continuing effects of slavery, but that's just not true at all. It's not true at all. In fact, it's quite the opposite. So that's the best answer I can give you. This is why I think it's a good agenda, and it's possible, but it takes a lot of organizing and power.
Mm-hmm. Mm-hmm. Interesting.
Thank you, Juan. Those are really interesting comments, and it's really insightful. I did want to, I want to actually turn to our next speaker. Okay, and I want to just give a brief introduction to Michael Claremont. He is the Charles Warren Professor of Legal History at Harvard Law School. Professor Claremont clerked for Justice Ginsburg when she was on the DC Circuit. He is the author of numerous books and articles, several books and numerous articles, many focusing on racial equality. Professor Claremont has won numerous awards for his teaching and scholarship, which are primarily in the area of constitutional law and constitutional history. He will speak on the degradation of American democracy. Michael?
Thanks very much, Thomas. I'm going to go quickly because we agreed we would each talk for at most 18 minutes or so, and I have a lot I want to say. So
Sure.
This is going to go pretty fast. So we're facing the most severe threat to American democracy that I think any of us have seen in our lifetimes. All of the following facts are true of today's Republican Party. 70% of its voters do not believe that Joe Biden is the lawfully elected president of the United States. More than 1/2 of all Republican state and federal political candidates who are on the ballot this year do not believe that Joe Biden won the 2020 presidential election. 60% of Republican voters believe that former President Trump did not possess classified documents at Mar-a-Lago. 60% of Republican voters believe that the people at the Capitol on January 6th, who killed several police officers and injured over 100, were peaceful and law-abiding. The Republican National Committee calls the attack on the Capitol on January 6th legitimate political discourse. And this is the party that more likely than not is going to take control of the House on November 8th. Let me say just a few quick words about Donald Trump. Throughout his 4 years in office, the former president, displayed an openly authoritarian bent. He attacked the press as the enemy of the people, assailed judicial independence, politicized the Justice Department and the intelligence agencies, encouraged political violence, delegitimized elections, called his political opponents traitors, and manifested a bizarre admiration for foreign autocrats. In the months immediately preceding the 2020 election, as we all remember, Trump refused to commit to a peaceful transition of power, declined to condemn white supremacists, and insisted that the only way he could lose the election was through fraud. After the election, he refused to concede, propagated baseless claims of voter fraud, sought to strong-arm state and local officials into finding votes for him and appointing fake electors favorable to him, and he incited a crowd of his supporters to march on the Capitol and obstruct Congress's certification of the Electoral College vote. Yet despite all of this, only 10 House Republicans voted to impeach Trump for inciting a coup against the government. Only 7 Senate Republicans voted to convict him on his impeachment, and only 2 House Republicans out of over 200 have been willing to support an investigation into what happened on January 6th. And despite all this, 78% of Republicans want Trump to run again for president in 2024, and more than 50% rank him as their first choice to be the party's nominee. American democracy is under siege today, and the assault comes from one of our great political parties. The anti-democratic practices of the GOP actually began at the state level about 15 or 20 years ago. Republican legislatures have suppressed votes through restrictive voter identification laws. They've purged the voter rolls, disfranchising especially young people, poor people, and people of color, all of whom are disproportionately likely to vote Democratic. Governor Brian Kemp of Georgia, who's won plaudits for not capitulating to Trump's demands to steal the 2020 election, purged 1.4 million voters from the registration lists while he was Secretary of State of Georgia from 2010 to 2018. Excuse me, he is Georgia's vote suppressor in chief, and he is very likely to be reelected governor next week. Republicans have grotesquely gerrymandered legislative districts, enabling them to maintain control of state legislatures and the House of Representatives while failing to win majorities of the vote. Excuse me for 1 second. In Wisconsin, it is almost literally impossible for Democrats to win control of the state legislature, even though they won the governorship in 2018 and the state's electoral votes in 2020. In Florida in 2022, Democrats will likely control only 8 out of 28 congressional districts, despite probably winning close to half the votes in the state congressional elections, thanks to an aggressive gerrymander demanded by Governor DeSantis, who is the most likely Republican to be the party's presidential nominee in 2024 other than Trump. Republican legislatures have also eviscerated the power of governor's offices after Democrats were elected to them. They've done that in North Carolina, Michigan, several other states. That is not normal behavior to deprive an office of traditional power simply because you lost an election for it. Republican state legislatures have simply rejected the results of voter initiatives of which they disapproved on issues such as raising the minimum wage and expanding Medicaid. They've also on felon disfranchisement as well, as was already mentioned. They've also imposed obstacles to putting such initiatives on the ballot in the first place and required that supermajority votes be achieved to enact them. This is from the party that purports to be the populist party of the people. Republican legislatures have implemented restrictions, excuse me. They've implemented restrictions on mass voter registration drives that have made them practically impossible to pursue. Let's try another sip of water here. The League of Women Voters has stopped registering voters in Florida for the first time in close to a century because the state made it impossible to conduct voter registration drives without risking massive criminal or civil liability. Since Republicans lost the electoral votes of Georgia and Arizona for the first time in decades, and then were defeated in 2 special elections for the US Senate in Georgia, several GOP-controlled state legislatures have launched the most systematic attack on voting rights since the 1965 Voting Rights Act sought to end race discrimination in voting. To take just one salient example, Georgia's recently enacted voter suppression law targets voting practices that have been used disproportionately by Democrats. The law makes it harder to obtain and cast mail ballots, drastically limits the number of drop boxes in the large population counties around Atlanta, expands the ability of poll watchers to object to voters, bans counties from establishing mobile polling places, virtually eliminates the use of provisional ballots for registered voters who show up at the wrong precinct, and criminalizes offering food or water to persons standing in line to vote. Now, democracy depends not just on broad access to the suffrage and free and fair election administration, but also on peaceful transitions of political power and the repudiation of political violence by all parties. Yet today, the threat of violence pervades American politics. The brutal assault on the Capitol by Trump loyalists is only the most salient example. Just last week, someone broke into the home of House Speaker Nancy Pelosi with the intent to maim her and nearly killing her husband. Several prominent Republican politicians have made jokes about that incident. 2 years ago in Michigan, Trump-supporting militia members tried to kidnap and possibly execute Governor Gretchen Whitmer for imposing lockdown measures during the COVID-19 pandemic. Republicans, Senate leader in Pennsylvania admitted that he feared I would get my house bombed if he dared defy Trump's efforts to overturn the election results in his state. The family of Georgia Secretary of State Brad Raffensperger received death threats for months after the election, including one text message to his wife warning that, quote, "We plan for the death of you and your family every day." Hundreds, if not thousands, of election workers have resigned or retired in the face of violent threats. Republican elected officials now frequently appear armed in photographs and campaign ads, and some of them, such as Marjorie Taylor Greene and Paul Gosar, have pretty directly encouraged violence against Democratic congresswomen. Today, 30% of Republican voters tell pollsters that true patriots may need to resort to violence to save their country. At a conservative rally last year in Idaho, a young man stepped to a microphone to ask when he could start killing Democrats. "When do we get to use the guns?" he asked as the audience applauded. "How many elections are they going to steal before we kill these people?" How do we get into this situation? Here are what I think are the 5 principal factors. Political scientists largely agree that racial resentment is the most important factor. In the 1950s, the US population was 90% white. Today, it's only about 56% white, and demographers project that within the next 20 years, the nation will no longer be majority white. The coloring of the nation, as exemplified by the election of its first Black president in 2008, has proved profoundly unsettling to many Americans, rendering them vulnerable to the appeals of a racist demagogue such as Trump. As late as the 1980s, the Democratic and Republican parties enjoyed the support of roughly equal percentages of white voters who registered high levels of racial resentment. But since then, those voters have become overwhelmingly concentrated in the GOP. In the 2016 Republican presidential primaries, racial resentment was highly correlated with support for Donald Trump. These are the voters who believe that white Americans suffer more from race discrimination today than Black Americans, still do not believe today that Barack Obama was born in the United States, favor building a wall on the Mexican border to keep out rapists and criminals, as Trump refers to them, and relish Trump's urging of Black and brown Democratic congresswomen to return to the shithole nations from which they came, even though most of them came from the United States. A potent second factor in the recent degradation of American democracy is the decline in the religiosity of Americans and a shift in the nation's religious demographics. Over roughly the last half century, the idea of America as a white Christian nation has collapsed. Hard as it is to believe, in the 1960s, Democratic and Republican voters hardly differed at all in their religiosity. The culture war issues of the 60s and 70s, such as prayer in public school, abortion, and the legal regulation of homosexuality, gradually pushed religious conservatives into the GOP. In the late 1970s, Jerry Falwell's moral majority mobilized millions of white evangelical Christians to participate in politics in support of Ronald Reagan and his party. Beginning around 1990 and accelerating since then, religious conservatives have come to recognize that they are losing the battles over the normalization of homosexuality and gay marriage, the loosening of sexual mores, and changing gender norms. In recent decades, religious conservatives have seen their children and grandchildren abandoning their churches in record numbers. Today, roughly 67% of Americans aged 65 and above are white Christians, but only about 29% of Americans aged 18 to 29. The number of Americans claiming no religious affiliation at all has more than tripled, from roughly 7% in 1974 to more than 25% in 2018 to 19. By 2024, for the first time in American history, white Christians may no longer be a majority of the electorate. These are profoundly disorienting developments for those who conceive of the United States as a white Christian nation, which is what it has been unofficially for nearly all of its history. The rise of neo-Ayn Randism is the third factor accounting for the recent degradation of American democracy. Radical libertarians who were politically marginalized after the Great Depression and World War II began a cultural and political comeback in the 1960s and 1970s. Libertarian billionaires such as the Koch brothers began investing in libertarian think tanks such as Heritage and Cato. They asserted their influence on college campuses through the Olin Fund and in law schools through the Federalist Society. They gained political ascendancy during the presidency of Ronald Reagan, who taught us that government is always the problem, never the solution. Extreme tax reformers like Grover Norquist, whose professed goal was to shrink government to the size where we can drown it in the bathtub, came to dominate the ideology of the Republican Party. The Ayn Randian Renaissance has culminated in today's Republican Party, which generally denies human-caused climate change, pursues tax cuts that overwhelmingly benefit corporations and the wealthy, and aims to eviscerate the social safety net. Good illustrations of this libertarian extremism are former House Speaker Paul Ryan's declaration that free school lunches for poor children give them a full stomach and an empty soul, and the statement by North Dakota Governor Doug Burgum in the fall of 2020, at a time his state had the highest per capita COVID-19 rate of any jurisdiction in the entire world, that placing legal limits on reckless behavior is not a job for government. The radical libertarians have never prized democracy because of the risk that a majority of the people would not support their plutocratic policies and would support the redistribution of wealth. The fourth factor contributing to democratic decline has been the enormous increase in economic inequality over the last 40 years. The wages of the American working class roughly doubled between 1935 and 1960, then doubled again over the next generation. During those years, blue-collar workers without college degrees, partly because of their strong labor unions, were able to buy homes and send their children to college on a single income. Their offspring were likely to fare even better economically. Yet since 1980, 2/3 of the gains from economic growth have gone to the top 10% of earners, and roughly half of that has gone to the top 1%. American workers now have lower life expectancies than workers in comparable Western democracies. Their babies have higher infant mortality rates, and they have worse access to health care. Life expectancies in some age ranges of the white working class are declining as a result of deaths of despair, so suicides and deaths from drug overdoses and alcoholism. Worsening economic inequality and the social pathologies it has produced created a golden opportunity for a racist, faux populist demagogue such as Trump to appeal to white economically dispossessed workers. while those workers ought to have been blaming their ills on globalization, technological change, and neo-Ayn Randian government policies, Trump and the Republican Party have sought to convince them that instead they should be blaming Mexicans, Muslims, and Satan-worshiping child molesters, as they would have it in the Democratic Party. Fifth and finally, several features of our political system, such as partisan primaries, winner-take-all districted elections, and the virtually unlimited flow of money into politics, have fed political polarization and negative partisanship. This has created a situation in which a deeply disaffected segment of the electorate has come to see their political opponents as existential threats to their way of life, to the extent that they're no longer willing to be committed to democracy if it will not protect that way of life. Technological changes in media and the altered media consumption patterns they have produced, the so-called Fox News effect, have further exacerbated these phenomena. Such forces have paved the way for an autocratic demagogue to take over one of our major political parties, something that would not have been possible for most of American history. In addition, various structural features of the American political system, geographic clustering, partisan gerrymandering, the vast malapportionment of the Senate, and the milder malapportionment of the Electoral College, together with its other vagaries, have made a minority party's control of government not only possible, but actually quite probable. For example, as Juan was saying, Democrats have now won the popular vote in 7 of the last 8 presidential elections, something that has not been done in all of American history, but they've only won the presidency 5 of those 8 times. Joe Biden won the popular vote by 7 million, but had 43,000 votes in 3 states switch sides. Trump would have been reelected president. Similarly, today, there are 50 Democratic senators and 50 Republican senators, but the Democrats represent 40 million more voters. Not once in the 21st century, through nearly a dozen election cycles, have Republicans won a majority of the votes cast for the US Senate, but they've controlled the Senate roughly half that time. Those features of the political system enable a minority political party to hold on to political power rather than systematically lose elections, which would require it to change its policies. Republican Supreme Court justices have been largely complicit with this assault on democracy. In 2013, they effectively nullified the pre-clearance provision of the 1965 Voting Rights Act. Since then, they've largely gutted Section 2 of the Voting Rights Act and seem likely to undermine the law further this term. Republican justices have also upheld strict voter ID laws and purges of the voter rolls on the basis of the state's interest in reducing voter fraud, which numerous studies have demonstrated is a virtually non-existent problem. A few terms ago, the Republican justices refused to remedy the problem of partisan gerrymandering, which today mostly benefits Republicans. They've also unleashed a virtually unrestricted flow of money into politics on the basis of contrived constitutional rationales, which disproportionately benefits wealthy donors, corporations, and well-funded interest groups. Rather than defending democracy, the court under Republican control has become another engine of democratic degradation. Just to finish up very quickly, Mitch McConnell ensured that the court was packed by stealing a seat for the first time in American history. McConnell insisted historical precedent supported leaving Supreme Court vacancies unfilled during presidential election years, but that was a lie. Never before had a Senate controlled by one party blocked a Supreme Court nominee made by the president of another party simply because the vacancy occurred during a presidential election year. In 2020, McConnell confirmed his hypocrisy by ensuring that the Senate confirmed the nomination of Amy Coney Barrett just 8 days before the election. The structural features of the American political system that permit minority rule that I just noted also enabled the Republican Party to pack the court in its favor, coming to dominate the Supreme Court despite winning the support of a diminishing minority of voters. Presidents George W. Bush and Donald Trump, neither of whom initially entered the White House with even a plurality of the popular vote, have supported 5 of today's 6 Republican justices. 4 of those justices were confirmed by narrow majorities of Republican senators who did not represent a majority of the American people. If the Senate and the Electoral College were more reflective of majority will, today's Supreme Court could not possibly have become the most conservative in the last 100 years. Instead, we have today's Republican justices aggressively advancing the agenda of today's Republican Party. Thank you.
Okay. Well,
Lisa, go ahead.
yeah. I read your article about the degradation of democracy, and I'm listening to what you're saying, and I have to say that I wonder, are we under threat or are we done? You know, I mean, how are we done? Is our democracy actually been hijacked? But I guess you could say that for at least for another week, the states are still democratic, and until we get someone in the White House who really is an unrestrained fascist, I guess we're still under threat. But it starts to feel like we're already there when you list those kinds of things, right? Okay.
So
And that's not a question, but
we're in the process of democracy being hijacked, but even if it had been successfully hijacked, we're not done. You're never done. There are lots of countries that had military dictatorships and then became more democratic. There are countries in the world that are suffering from democratic degradations, and there's hope that they'll fight and come back. Brazil, unelected their wannabe autocrat, and I'm sorry, you didn't want me to answer that. That wasn't
no. I mean, I felt like when I was thinking about your frog slowly boiling to death, that maybe the frog has already died and democracy is done. But I take your point. And yes, in Spain and Portugal and other countries, they have been through fascist periods and emerged as more or less democracies. So I don't think we're done in the broad scheme of things, but we're in such bad shape here. So I guess I wanted to ask you a couple of questions about that. You know, again, sort of the question I put to Professor Perea is, what do we do? What can we do? What's the best thing to do? I mean, you focus on the Supreme Court, and I appreciate that. I think that's a very realistic suggestion, but then I wonder, how will that ever get passed? And as you say, the Supreme Court would be asked to hold it unconstitutional if we voted to expand the Supreme Court.
So Democrats have wasted an opportunity. This is a tragedy. Democrats should have created new states. District of Columbia should be a state. The only two reasons it's not a state are because of racism and partisanship. Puerto Rico should be a state if it wants to be. Its population is larger than 20 states. Democrats should have broken the filibuster and passed voting rights legislation. And in my opinion, Democrats should have expanded the court. Now, there are, I believe, nearly 50 Democratic senators who would break the filibuster for voting rights legislation, but they didn't because Joe Manchin and Kyrsten Sinema are either have a set of incentives that I can't quite figure out, or else are too ignorant to understand the threat to democracy. The problem is that this was Democrats' best chance. Democrats going forward will have very little chance to win the Senate. And I don't mean on Tuesday. I think the odds of the Senate are 50-50, but this is a very good election cycle for Democrats. Democrats had a very good chance to win Pennsylvania, win Wisconsin, win North Carolina. After the next election cycle, it is not an exaggeration to say Democrats may never win the Senate again. So we're going to need some pretty significant and creative solutions. I'm not really worried about the Supreme Court striking down court expansion. I'm worried that enough Democrats don't yet understand the emergency and are willing to take emergency stands in response. If you expand the size of the Supreme Court and 4 Democratic justices take their seats the next day, they'll be part of the Supreme Court voting on whether court expansion is constitutional. So I don't see any practical way that today's, aside from the fact that it's a really bad constitutional argument to strike down court expansion because the size of the court is not set in the Constitution. It was changed a half dozen times in the 19th century, including for partisan reasons. I'm not even advocating doing it for partisan reasons. I'm advocating doing it because the Republicans have packed the court and Democrats were entitled to the majority for the first time in 50 years when Scalia couldn't make it to the end of the Trump administration, to the Obama administration.
Right. Okay, I just wanted to.
Lisa, I think we're gonna have to move on.
Oh,
but-
okay.
But I want to thank you, Michael, for marshaling, such terrific arguments on this. I did want to mention, because Juan Perez had to leave us, his flight took off. Because Juan was in that situation, I didn't have a chance to introduce my colleague, Lisa Griffin. And I would like just to mention that now. My distinguished colleague, Lisa Griffin, has done particularly noteworthy scholarship in criminal procedure and ethics, both from a comparative and domestic perspective. She just returned from Spain, where she served as a Fulbright scholar. She would be, and she is, working, in the capacity of a moderator here, co-moderator here of this panel. I did want to just mention, because I was going to mention this in my introduction, but because we wanted Juan to be able to speak, we skipped that. But I just wanted to kind of underline a couple of points before we go on to our next distinguished speaker, and that is that voting is the foundation of democracy in our country and every democracy in the world. Voting is among the most fundamental, if not the most fundamental, rights in a democracy. When a people collectively choose their representatives and leaders in a free and fair election, that electoral system and process affirms that we are all governed by free choice. A vibrant democracy depends not only on the process and system of voting, but also on elected leaders and citizens who will accept the results of fair and free elections. Unfortunately, and Mike just elucidated, so many aspects of this where this is abused here in the United States, but it's not limited to the United States. Many countries restrict, dilute, or otherwise deny the right to vote, and their leaders often refuse to accept that they have fairly lost an election. I have to say, tragically, the United States, appears to be among these countries. So I just want to underline one point, and then we'll move on to our next speaker. For the first time in over 2 centuries since the United States was founded, a president who lost a fair and free election has not only refused to concede, but has also launched, as Michael pointed out, a propaganda campaign about the integrity of the election, inspired his followers to commit violence, and prompted over 20 states where his party controlled the legislature to enact ever restrictive voting laws, as Juan pointed out. So, not to mention the constellation of voting suppression tactics that was mentioned by both Michael and Juan. I would just add one more, which I don't believe was mentioned, and that is enabling election deniers to gain control of polling places and voting administration. International human rights law recognizes the fundamental right to voting, okay? And both in the International Covenant on Civil and Political Rights, which the United States is a party, as well as the Universal Declaration of Human Rights, UN treaty bodies monitoring human rights conventions, the European Court of Human Rights, the Inter-American Commission and Court of Human Rights, and other international bodies, as well as domestic courts and legislatures. Now, this really brings me up to our next and third speaker. Penny Venetis is the Dickinson R. Du Bois Scholar at Rutgers Law School, where she is a distinguished clinical professor of law and the director of the International Human Rights Clinic. She has taught at Rutgers since 1993. Professor Venetis is an expert in both civil rights law and international human rights law, and pioneered efforts to integrate international law into U.S. law. Her scholarship focuses on the intersection of human rights and constitutional law. She has been working on voting rights issues on the national and international level for 30 years, making sure that computerized and other voting systems produce a verifiable paper ballot, so critical in today's times. She has also engaged in international litigation regarding, among other things, how felony disenfranchisement violates human rights. She will be discussing her clinic's petition to the Inter-American Commission of Human Rights, challenging the United States' widespread law and practice of felony disenfranchisement. Penny?
Thank you. Thanks everyone for attending this webinar. It's really, really critical for us to identify ways in which voting is restricted and to try and find solutions, although, as you heard, the situation is pretty bleak. But I too believe that things go in cycle and that we have to keep chipping away to try and defend voting rights as much as we can. And it really is like playing whack-a-mole. Just when you turn your back, new laws are enacted that prevent people from voting. To just name a few, and some were discussed previously, but, calls telling people that election day, the date has moved, purging the voter rolls, fighting against ballot drop boxes, or severely limiting the use of ballot drop boxes and vote by mail in Black and brown neighborhoods, opposing early voting, the list goes on and on and on. In 2020, at the height of the COVID pandemic, during the primary season, I was involved in roughly 10 lawsuits to try and make sure that people were able to vote by absentee ballot. And at that point, it was pre-vaccine. And it really was for people, particularly in Black and brown neighborhoods, a choice between voting and catching COVID and potentially dying. These are the problems that we can identify. These are the problems that we see, we can speak out against, we can publicize them, and we can at least have a discussion about, how these forms of voter suppression are illegal. But there is a form of voter suppression that people really don't think about all that much. And, Juan touched on it when he talked about felony disenfranchisement. So what is felony disenfranchisement? Felony disenfranchisement is when people who have committed felonies are automatically disenfranchised. They cannot vote. And it is very common in the United States. 48 out of 50 states automatically disenfranchise people after they have been convicted of a felony. The only places where people who have been convicted of felonies who are incarcerated can vote are in Maine and Vermont, where the population is largely, the prison population is largely white, and also in Puerto Rico and DC. And DC is very, very recent, and as well as Puerto Rico. So today, 5.2 million US citizens with criminal convictions who are over 18 years old and who otherwise would be eligible to vote are disenfranchised because of state laws steeped in the history of Jim Crow, which Juan talked about, and anti-Black racism. These laws have been condemned internationally for over 2 decades, yet they persist. According to a 2021 report by the Sentencing Project, and I'm going to quote, Black Americans of voting age are nearly 4 times as likely to lose their voting rights than the rest of the adult population, with 1 of every 16 Black adults disenfranchised nationally. As of 2020, in 7 states, I won't list them, more than 1 in 7 Black adults are disenfranchised. In total, 1.8 million Black citizens are banned from voting. In 34 states, the Latinx population is disenfranchised at a higher rate than the general population as well. Felony disenfranchisement falls into roughly 4 categories. One I mentioned, where there's no restriction. Then there is 21 states, so that's 4 jurisdictions, Maine, Vermont, DC, and Puerto Rico. Then there's 21 states where you are disenfranchised only as long as you are imprisoned. That's 21 states. Then there are 16 states where people are disenfranchised even after they have served their sentences and while they're on probation and parole. And then there are 11 states where people are disenfranchised almost permanently in reality, even if the laws seem to indicate otherwise. This is perfectly legal. There's a 1974 US Supreme Court case called Richardson versus Ramirez, where the Supreme Court held that it was not a violation of the 14th Amendment for states, in that case it was California, to disenfranchise people who have been convicted of felonies. The Ramirez case has been criticized widely, yet it is still valid law. And as recently as August 2022, the Fifth Circuit Court of Appeals held that Mississippi's voter disenfranchisement law was not unconstitutional because there was no evidence of racial bias, even though Juan's scholarship shows otherwise, and even though it's fairly obvious historically that many activities of African Americans, former slaves, were turned into felonies to prevent them from voting. The laws, in addition to really keeping a large percentage of people of color from voting, also are anti-democratic for other reasons. So, and I'll give one example, which is Florida. In 2018, over 60% of Floridians voted to approve an amendment to the state constitution, known as Amendment 4, or the voting amendment, to re-enfranchise people with certain felony convictions after they had served their sentences. And this included people who were on probation and parole. There were some exceptions, yet after it passed, the legislature immediately passed a law. So the voters voted to amend the Constitution, yet immediately afterwards, Governor Ron DeSantis signed Bill 7066, which basically effectively overturned the re-enfranchisement law. And basically, the law said that one could not become re-enfranchised unless they actually were able to pay their fines and their fees, outstanding fines and fees related to their crimes. It was almost impossible to find out what the fines and fees are. I've worked with several people who have attempted to do that, particularly during COVID, and it was just impossible to find out what that is. And there was a lawsuit that ensued saying that, this was undemocratic and it disenfranchised people. The U.S. Supreme Court upheld the Florida law, saying that the state had no obligation to inform people of what fines they own. So we have people who the Constitution says can vote, but they can't vote because they owe money, but they can't find out how much money they owe. Then there are states that say people can be re-enfranchised, but states like Mississippi, for example, allow people to vote if they're pardoned by the governor, or if their right to vote is restored by a 2/3 vote of both houses of the state legislature. Well, these are insurmountable obstacles. Few people have the resources, education, or ability to prepare the legal documents needed to request pardons and petition the legislature. The government is busy, and particularly during the COVID-19 pandemic, nobody was spending time reviewing requests for pardons so that somebody could vote. And there are states like Texas and Florida, you may have read about recently, who are prosecuting people who inadvertently voted because they didn't know they were disenfranchised. I'm going to give an example of two instances that took place in Texas. In Texas, there was a woman who attempted to vote. She didn't know she was disenfranchised, and she voted by provisional ballot. So her ballot was never, ever counted. She was sentenced to 5 years in jail by a Republican judge. So she was sentenced to 5 years in prison for illegally voting, even though she actually never voted and her vote was never counted. Yet the same Republican judge sentenced a white Republican judge who pleaded guilty to intentional election fraud to only 5 years of probation. So you have a racially disparate set of sentences by the same judge, giving someone who admitted to voting illegally 5 years probation, and giving someone who actually never voted in the end a 5-year sentence. Now, because of the public uproar, the 5-year sentence was indeed rescinded, but it took the effort of thousands, if not millions, of people to actually get that election, to get that sentence overturned. So it's legal to have felony disenfranchisement in the states, and Congress has been completely ineffective in getting rid of it as well. There were efforts in 2019 and 2022 by the House of Representatives to actually get rid of some form of felony disenfranchisement, and that was only for people who had served their sentences. So it it continued to allow people who were incarcerated to be disenfranchised, and only in federal elections. So it would not impact state elections. Yet that failed. It just fizzled out. It seemed like it was a pipe dream rather than something that is a real necessity. I want to just talk about the disparate impact. I know that Juan mentioned it, but I think it's really important to note because it's a really critical part of the lawsuit or the petition that I filed before the Inter-American Commission on Human Rights. So felony disenfranchisement impacts communities of color at a disproportionate rate, silencing their political voices and weakening their overall political power. The US has the highest rate of incarceration in the world, and the racial imbalance in US prisons is striking, appalling, and shameful. Black men are 6 times more likely to be incarcerated than white men, while Latino men are 2.5 times more likely to be incarcerated than white men. 1 out of every 3 Black and one out of every 6 Latino boys will be sentenced to prison in their lifetime. In contrast, 1 out of every 17 white boys can expect to be sentenced to jail or prison in their lifetime. Those are still, horrific numbers, but the racial disparity is really appalling. Even though Black and Hispanic people make up 32% of the general US population, they make up 56% of the US incarcerated population. And more than 25% of Black men are jailed by the time they're in their mid-30s. Some states are worse than others. So I'll just give a few examples. In Iowa, for example, the racial disparities in prisons are more extreme than almost anywhere else in the country, with Black Iowans imprisoned at a rate of 11 times that of white Iowans. The 2010 census showed that although just 4% of Iowa's population was Black, at the time, 25% of incarcerated Iowans were Black. Similarly, in Florida, even though 16.9% of the population is Black, a staggering 40.9% of the prison population is Black in Florida. In Texas, Black people constitute 13% of Texas state residents, but 27% of people in jail and 33% of people in prison. Latinos, it's not quite as bad, but it's still pretty appalling. For example, Latinos constitute 49% of New Mexico's population, but 60% of the state prison population, 16% of Connecticut's population, but 28% of the state prison population, and 12% of Massachusetts population, but 28% of the state's prison population. And that's Latinos. 20 years ago, working with my colleague, Frank Gaskin, who has since passed away, we challenged felony disenfranchisement laws in New Jersey using the state constitution because there have been so many unsuccessful challenges to felony disenfranchisement on the federal level. And we thought we had a pretty decent shot because the New Jersey Supreme Court has always been very strong on issues involving individual liberties, constitutional rights, the right to vote. So we thought if we could succeed anywhere, it would be in New Jersey. And we really had the right ammunition because the Attorney General had just issued a report, actually acknowledged that that there was such a thing as driving while Black in New Jersey, and that the state police was racially profiling drivers of color, particularly Black drivers. So we had proof that a disproportionate number of people of color, particularly Black people, were being stopped on the highways. They were being arrested, and it's a domino effect. And as a result, they either pleaded guilty or they were sentenced at a disproportionately high number. So we thought that we had, the ammunition to show, yes, this is felony disenfranchisement is race-based, and we challenged felony disenfranchisement under the state constitution. And to our surprise, we lost. And it was the first challenge under state law. We decided not to stop there. We filed a petition before the Inter-American Commission on Human Rights. And there it sat for 16 years, despite my best efforts of, sending the commission regular, updates, visiting the commission, getting elected officials to, try and exert their influence to get the commission to respond. Nothing happened. And it really was the death of George Floyd that really, seemed to actually light the fire under the commission's feet to say, we really have to do something. This is clearly race-based in the United States, and we have to act in some way. I mean, that's just me guessing, but the timing is it really is. I don't think it was a coincidence. And I, in my briefings to the commission, talked about George Floyd's murder and the racial reckoning and the need for to stop this blatant suppression of Black political power. So the petition is now active before the commission, and the legal arguments. I'll touch on the major legal arguments. There are a whole slew of them, but I'll touch on the major parts of the arguments. So the petition says that felony disenfranchisement violates the American Declaration on the Rights and Duties of Man. It's a petition. I mean, it's a treaty that the U.S. has signed, and it also gives the Inter-American Commission on Human Rights jurisdiction over the U.S.'s actions once the all of the legal challenges within the United States or with any state within the commission's jurisdiction, once those have been exhausted. And we showed that that was the case because we lost at the New Jersey Supreme Court level, and we also cited to the commission all of the federal cases where federal judges, including the Ramirez case from 1974, saying that it was not a violation of the U.S. Constitution for states to disenfranchise people who have committed felony crimes. So, so the first argument that we made is that U.S. felony disenfranchisement laws violate Articles 20 and 23, or sorry, 32 of the American Declaration. So, so voting is a fundamental right of every citizen in the Americas, according to the American Declaration. And the American Declaration says every person having legal capacity is entitled to participate in the government of his country directly or through his representatives, and to take part in popular elections, which shall be by secret ballot and shall be honest, periodic, and free. And the American Declaration does not in any way restrict the right to vote. There are no exceptions. It says it is an absolute right. So there's this, the commission interpreting the American Declaration really embraces as a universal right, the right to vote as absolute. So, so the argument that we made was that felony disenfranchisement violates that absolute right. And it's the right to vote is unqualified, and that felony disenfranchisement is a form of restricting that absolute right. And there's case law that we cited, and also statements that have been made by the Inter-American Commission. So in 2016 and in 2018. The commission issued a thematic report that basically said that people on probation and parole should be fully enfranchised when they're released from prison. Our argument to the commission is, well, that's too restrictive anyway, because human rights law itself actually is much broader than that. And we cited cases from the European Commission, the European Court on Human Rights, and also the Inter-American Court on Human Rights. There's a 2014 case called Norin versus Chile, where the Inter-American Court held that statutory permanent stripping of political rights, including the right to vote, even when someone is convicted of terrorism, could not stand. So that was a case in the Inter-American Court, which the commission looks to. And also there are 9 decisions out of the European Human Rights Court. The first of those decisions is from 2005. It's called Hearst versus United Kingdom. And that really is the foundational case. And actually the Noren case cites to that case. And it set the foundational precedent that a blanket ban applied automatically to all individuals convicted of a crime, disenfranchising them regardless of the length of their sentence, the nature or the gravity of their offense, and the individual circumstances of a particular crime, that this blanket disenfranchisement violates the European Convention on Human Rights, which is similar, the wording is similar to the Inter-American Convention on the Rights and Duties of Man and the other treaties, human rights treaties. And since the 2005 Hearst decision, there have been 9 other decisions within the European Court. And I won't go through them, but they basically say it's irrelevant whether the absolute ban is statutory or constitutional. It's still, you can't have that. You really have to actually look at the individual crime that's committed and determine whether the type of crime is such that one can be disenfranchised. So, for example, any case if somebody is convicted of voter fraud or of election fraud or of voter suppression, then, the case law says, well, in those circumstances, if you look at the totality of the situation, that disenfranchising someone could perhaps be an appropriate outcome if the judge actually looks at all of the circumstances surrounding the conviction. But a blanket disenfranchisement doesn't violates human rights law. So it's not only those international courts, but it's also courts around the world in their domestic law that have also found that have adopted the European Court of Human Rights reasoning, eliminating blanket felony disenfranchisement. So there are 19 countries in total that have adopted straight out the European Court of Human Rights reasoning from the Hearst case. And I also want to point out, Israel, for example. So in those countries, basically, there could be disenfranchisement, again, if there's a crime committed against the state, capital S, right, against the country. But in application, it seems like it's almost, the courts have never found that there was such a violation. So I'll give the example of Israel. So in a case that was brought by Yigal Amir, the person who assassinated Prime Minister Yitzhak Rabin, he was so Yigal Amir was disenfranchised, and he sued, and the Israeli Supreme Court actually said that his assassination of Prime Minister Yitzhak Rabin was not a crime against the state for which one could be disenfranchised. And if that's not a crime against the state, then really it's a very, very high bar, which means in those countries almost everybody can vote while they are incarcerated. So that's the first part of our argument, and there's case law that we cited from around the world, including in the Americas, saying that the right to vote is absolute, and you can't just blanket disenfranchise people like happens in the US, where the sentencing judge doesn't even say you've been disenfranchised. It just happens automatically by statute. You need to conduct this proportionality test, and you need to look at the individual circumstances, but the bar is very, very high. The second argument that we make is a race-based argument, basically saying that there is discriminatory intent, so that Article 2 of the American Declaration is violated because there's discriminatory intent in felony disenfranchisement laws, and basically that were enacted in a way to circumvent the 15th Amendment. So I'll go through our arguments. on those lines. So
Penny, could I ask you maybe to wrap it up? It's just that we would like to have a little time for questions if possible. I wonder if you could do that. Okay.
okay, I'm almost done.
Okay,
So,
great.
so Article 2 provides all persons are equal before the law and have the rights and duties established in this declaration without distinction as to race, sex, language, creed, or any other factor. So, so there's basically an equal protection clause. And unlike in the US, the Inter-American Commission has read a disparate impact analysis into this equal protection clause. So, I mentioned earlier the disparate impact that felony disenfranchise has on people of color, particularly Black Americans. And there are other international bodies that have condemned the US because of this disparate racial impact. I'm going to name the International Convention on the Elimination of All Forms of Racial Discrimination Evaluation Committee in 2001, UN Special Rapporteur on Contemporary Forms of Racism, Racial Discrimination, Xenophobia, and Related Intolerance in 2012, the Human Rights Committee in 2014, UN Special Rapporteur on the Extreme Poverty and Human Rights 2017, and most recently in 2021 by the Working Group of Experts on People of African Descent. So the US has been called out on this. We say, in addition to the racial motivation and the disparate impact, that there are several factors that contribute, other racist factors that contribute to felony disenfranchisement, such as racial profiling, which I mentioned earlier, driving while Black. Felony disenfranchisement is a product of over-policing and mass incarceration, which disproportionately impact communities of color. And the third thing that no one's touched upon that I really want to talk about is prison gerrymandering. And I'll try and speak very, very quickly, but most people don't know what this is. And actually, it really is like, it's a double whammy. And to explain prison gerrymandering, I'll just give an example of Texas, okay? So Texas, which has some of the nation's most restrictive felony disenfranchisement laws in the country, exemplifies how prison gerrymandering radically dilutes the political voices of Black and Latino communities. So the majority of Texas's incarcerated persons come from the most populous counties in the state. So 15% of incarcerated people are from Harris County and 9% are from Dallas County. And both of these counties, this is significant, are majority minority counties, which means the majority of the population are racial minorities. So in Harris County, 44% are Latino and 20% are Black. Dallas County, 40.8% are Latino and 24% are Black. Yet both Harris and Dallas counties each house less than 2% of Texas's prison population, okay? And this is significant. So you can't vote while you're in prison, but you're not even incarcerated in your neighborhood, with your community where your family can visit you.
Okay. We have a question from, I think this might be to Michael. It seems that corporations influence the racist agenda of many politicians and judges in states that historically have deprived their citizens of rights. These corporations influence the economies of state and pockets of political leaders in ways that seem to overwhelm voting rights efforts. How do we advocate in the face of corporate giants that seem to be doing everything to keep politicians in their corner?
None of these problems are easy to solve. If Merrick Garland had been the 9th justice on the court, then the Supreme Court might very well have changed some of its campaign finance jurisprudence. All of this is an invention of the Supreme Court in the last 45 years. For nearly the first 200 years of the country's existence, I don't think anybody thought that spending money in politics was a First Amendment right. The so-called textualists and originalists have completely made this up without any grounding in the original understanding of the First Amendment. And it's an outrage, but it's almost impossible to get a constitutional amendment to overturn it. There's no other country in the world that allows this insanity. I think nearly $10 billion has been spent in this election cycle. In the presidential election cycle, it was $15 or $20 billion. Politicians are just owned by some of these corporations and big donors. We now have Peter Thiel, who basically is trying to own a senator from Arizona and Ohio. And it's a crazy system. And of course, those people are not pursuing the public good. They're pursuing the interests of their donors. I don't know that the corporations are particularly committed to a racist agenda. They have a neo-Ayn Randian agenda. They want corporate tax cuts. They want lower safety nets. If they're fossil fuel companies, they don't want anything to be done about climate change. The problem is those are not popular political agendas, and Republican politicians who are pursuing those agendas understand that you can't run on those agendas. So what you have to run on is racial resentment, fear of crime, the loss of white Christian America. So it's not an accident that these things happen at the same time. But you know, the Koch brothers don't want violent overthrows of the government. The point is that they want a neo-Ayn Randian agenda, which works up the white working class, and the white working classes has become so devastated by that economic agenda that they're susceptible to racist demagogic appeals. So they've kind of created a monster that they don't know really how to deal with.
There's another comment that says it sounds like the 3/5 clause, but I would also like you, Michael, to comment in the remaining minutes, and then maybe we'll get a chance for a question for Penny too. And that is, what is the strategy going forward? I mean, you paint an extraordinarily bleak picture. I wonder if you could, and this, you know, Lisa kind of asked you this question too, but I wonder if you could expand on that just a bit.
So I'm glad you focus on that, because I don't want people to take away the lesson that there's no hope or that you give up. That's the wrong lesson. The lesson is, of course, you always fight and you struggle. And you know, if Thurgood Marshall had given up, we would never have gotten Brown versus Board of Education, and the women's suffragists could have given up. They were fighting for 50 years. The gay rights movement could have given up, and now we have gay marriage. I'm actually pretty optimistic in the long term, because my students who are in the 20 to 30 age range, if they were running the world, we wouldn't have any demagogic appeals by racists, and Christian nationalism would have a very small constituency, and you wouldn't be able to demagogue voters about transgender bathrooms, and we'd do something serious about climate change. The problem is the interval between when those people take charge, both of American politics and world politics, and the time that this demographic, and it's a wing of the Republican Party. It's not a majority of the Republican Party, but given gerrymandering and given money in politics, they dominate the agenda. These are the people who want to restrict abortion rights completely, basically no abortions. They're the ones who want the don't say gay laws. They're the ones who want to go after parents for child abuse, for trying to do something to help their transgender kids. You know, I don't know what they are, 10 to 20% of the American public, but because of the gerrymandering, there are no competitive districts anymore. We're going to face a really difficult, trying time for the next decade or so, and turning over the keys of the House of Representatives to the party of crazy and the party of stochastic terrorism is a pretty bad idea, and we're about to do that. So I think, you know, the next 10 years, people are going to have to do everything that they can to make sure that these people do not gain control of the government. If it means voting, if it means writing postcards, if it means knocking on doors, if it means giving talks to persuade people how dire the situation is. But the lesson is not that democracy is inevitably doomed. Of course it's not. I mean, we're in better shape than Poland and Hungary. And you know, the Philippines just voted by 2-1 for the child of a former dictator. Republicans can't win a popular vote in the presidential election in the United States, right? The majority's on the right side. The problem is it's not clear majorities are going to control the political outcomes.
If I could just ask, thank you, that was a great answer. Penny, just kind of following up on Lisa's question, assuming you do win in the Inter-American Commission of Human Rights, do you see that win as primarily symbolic, as trying to engage the world community, you know, in this matter, as a way to put some perhaps outside pressure on the United States? Where do you see it as really achieving a concrete benefit for the disenfranchised here in the United States?
I don't think it's, I mean, it's not, we're not doing this to get a symbolic victory on a piece of paper. I spent 20 years of my life, you know, trying to keep this issue alive with others. Now there's a coalition of people who, when we first started, you know, people were scratching their heads and, you know, thought it was, you know, it was a very unusual thing to be advocating for 20 plus years ago. there's a really strong grassroots movement, and I do think that it could be helpful on the state level. And as Michael said, if we have this ruling, and I think the same thing about my students as well, that we have a gerontocracy, and hopefully the next generation takes over, will be more attuned to civil rights and human rights, and we'll have this decision. And there are people on the ground, there are legislators that I'm working with around the country who are trying to change the law on a local level. And if they have this decision, and if the commission issues a favorable decision, it will be lengthy, and it will really, we gave them enough information about historically, sort of the impetus for these laws, and also just the impact and the numbers. And I think we gave them enough to write a really, really thorough opinion that then folks can take to perhaps try to amend their constitutions on the state level, or to try and pass legislation and to show that this violates human rights. So it's not just for symbolic purposes. We really are hoping that this will have an effect. And I do think that there'll be I'm hoping that there'll be a domino effect, that it will start slowly, but once these laws start passing, that they will gain traction. I mean, look what happened in Florida, right? 60% of the population voted to get rid of felony disenfranchisement, and through shenanigans, the legislature and Governor DeSantis managed to undo the popular will. It goes back to what Michael is saying, these, sort of backhanded ways to try and undercut democracy. So this, I think, will help to galvanize the public and to change laws on the local and state levels.
Okay, thank you. Lisa, did you have any additional questions, or
No,
any
I think
additional
that's it.
questions from the audience before we leave?
Everybody?
I'm sorry, did you say you
No.
did not? Okay, well, I wanted to thank all our speakers. Michael Clairman had to leave. One parade took off on his flight. I want to thank you, Penny, for being with us today, and also my colleague Lisa Griffin for doing a terrific job in asking initial questions. Take care. This will be it has been videotaped. I should say video recorded, and no one uses tape. This has been video recorded. We will be posting it to the section on the section page. Take care. Good luck, and vote on Tuesday. If you haven't voted already.